Go live on YouTube?
I picked the wrong address.
No.
I
Oh,
think
okay,
it's
got you.
working now.
I don't know if he's here to plead guilty or if we're set for a PV hearing. I think probably a plead guilty to the violations, but I'm not sure.
All right, so Mr. Kiesel, this is set for a bond violation.
PV, probation.
That's what I said.
We said
PV.
bond.
Oh, did I
That's
say
all right,
bond?
yeah.
Okay, probation violation hearing today. And it's my understanding you were in front of the magistrate and indicated that you wanted to plead guilty to the violation. Is that true?
That's correct.
Okay. So I need to go over some rights with you first to make sure you understand those. You do have a right to a hearing to contest the charges against you, and you have the right to an attorney, including one appointed at public expense if you were unable to afford. Do you understand that?
Yes.
Do you also understand that the worst that could happen is your probation could be revoked and you could be sentenced to up to 93 days in jail? Do you understand that?
Yes, Your Honor.
Okay. And you want to waive your right to both a hearing and an attorney, admit to the violations, and be sentenced then, correct?
Yeah. Yes, Your Honor.
All right. Nobody's used any force or threats or coercion to get you to plead guilty, and no one's promised you what would happen or what I would do if you plead guilty, have they?
No.
Okay. So it's your own free will to plead guilty to the violation at this time.
Yes, Your Honor.
Okay, so is it true you were placed on probation for drunk driving back in April of 2021? And as a condition of that probation, you were not to consume or possess alcohol.
Yes, Your Honor.
And you were also ordered to take tests to prove that you weren't using alcohol, correct?
Correct.
And according to the report, it says that on April 29th, you did test positive for alcohol. It was a 0.02 and a 0.017 reading. And on May 13th, it was a 0.067. And you also were asked to retest, and you didn't do that on the 13th. Is that all true?
That's correct.
Okay, and that's because you did consume alcohol on those 2 dates, correct?
Correct.
All right, it also alleges that on May 5th, May 16th, and May 17th, you missed preliminary breath tests. Is that true?
That is correct, Your Honor.
Okay. Then to those violations, how do you plead?
Guilty.
Okay. I'll accept the plea, find it's voluntary, accurate, and understanding. So the report indicates that you would rather just sit in jail than do the probation. Is that still true?
Yes, Your Honor.
Okay, is there anything else you'd like to say to me then before I sentence you?
I don't believe I have anything to say, Your Honor.
Okay, give me a minute. All right, well, you know, you're here because you went off the road into a ditch. You had a 0.21 or a 0.19 blood alcohol concentration, and a substance assessment showed that you do have a substance use disorder. And apparently that's obviously true, because rather than simply not consuming alcohol, you keep drinking and violating your probation. So do you have any plans to do something about that?
I planned on, if I did get the sentence, I just planned on coming home. I had a good talk with a family member of mine. I mean, yeah, it's just a conversation, take actions, speak louder than words, but I just planned on coming home and working and just trying to be the best that I can do for my son as well, and prove to him that, you know, I can be there for him more than I am, you know, drinking. So.
All right. Well, it's going to be difficult for you to accomplish that if you're not willing to get some counseling, go to 12-step meetings or whatever it takes to overcome that problem.
Right.
So I'm real concerned for you. You know, you're only 25 years old, and the future does not look bright if you don't get the alcohol problem under control. However, given the fact that this is a first offense, and I'm not going to give you the full 93 days. So let me see here. So I believe you had 2 days credit for time served when the violation was submitted. So what I'm going to do is impose an additional 30 days in jail, given the fact that you haven't really accomplished any of the goals of the probation, and there remains a likelihood that you're going to reoffend because you're not addressing the problem.
Right.
So I do wish you luck trying to find help on your own. You need to turn yourself into the jail. I'll give you until 4 o'clock this afternoon, and that's again 30 additional days. There's no credit for time served, and we'll preserve any fines and costs, and probation is revoked as unsuccessful. Thank you. You're all set for today.
Thank you.
All right. Are you Mr. Mikovits?
I am, sir.
You're, oh, okay, great. Okay, well, we're still waiting for your attorney to get here. I assume Mr. Pedersen's going to be here. And then we'll get started. So we still got a couple minutes. I'll be in recess until that time.
Thank you.
Okay, Mr. Pedersen, are you ready to get going?
I am. Good morning.
Good morning. All right, I'll let the judge know. We're ready to go when you are.
Tim, you can unmute yours. Oh, you did. Okay.
I already did. Good morning.
Okay.
Where are you going? Oh, what's your notes?
All right, this is People versus Timothy Mikovits, file 211527 SD2, and Mr. Pedersen is here on the defendant's behalf. And this is the date set for a bond hearing. Mr. Pedersen, have you been provided with notice of the violations that have been reported?
Yes, Your Honor. And mine's this of course is a continued bond hearing from the 21st of May.
Okay, and let's see. So I'm trying to recall what the outstanding issues were. I think you were not given that information originally, or there were more violations than you were aware of. Is that?
Well, yes, that's true in part, Your Honor. When you were doing the other hearing, and my associate Jordan ACO handled that, so I wasn't in that hearing, but my understanding and for what I've reviewed, there were several quote unquote skip tests over many different periods of time. And what was relayed to the court was that I think Mr. Mikovits is on his second or third machine. He had trouble, frankly, correctly testing early on, wasn't providing enough sample because he couldn't, had to go from the handheld unit to a hard unit, the older fashioned one. And it's my understanding since the 21st of May, the problem has largely resolved itself. He was also taking some tests outside the window. So for example, he had to get up and go to court. He'd take the test at 6 in the morning, or 5:45, and his window is between, I think, 6 and 9 a.m. And he was taking some tests before the window, so they were registering as skip tests. And we've impressed upon Mr. Mikovits that you can't just turn it on and test whenever you want. It's during that prescribed time. So I think we have since, as far as I know, straightened out the machine issues and Mr. Mikovits' understanding of when he must test. His daughter is there with him in the room behind him. She's been trying to help him. Mr. Mikovits is a 75-year-old man with limited, we'll call it technical skills, and it's manifested itself in use of the breathalyzer machine and this technology. So we're trying to help him through that.
Okay, well, so Mr. Mikovits, you understand there are testing windows and you have to test within those, and you're going to keep doing that?
Yes, I completely understand. It's between 6 and 9 in the morning and 6 and 9 at night. And I religiously completed all those. I was misunderstood about how to do it.
Okay. With regard to the positive reading that we had on April 10th, I guess I'm going to overlook that because the reading was so low. It's a 0.006. That's what, 6/1000ths. And I'm not sure that I could ever base a ruling, a finding that alcohol was used on such a low reading.
That's correct.
So I guess this is what we're going to do is I will continue the bond as is. And I guess now that we're all straight on what the testing window is, and I won't expect any additional violations from here on out. And as long as that continues, we'll allow Mr. Mikovits to remain out on bond with the same conditions. So is there anything else for you, Mr. Patterson?
Well, no, Your Honor. I know Mr. Donaldson's there. We have spoke previously. I don't think we turned in a pretrial memorandum. We had reached an agreement on a plea to be tendered in this matter. So it's my understanding that the next thing that needs to take place is it to be set for a plea, or take a plea today if the court prefers.
Okay, well, we can go ahead and do the plea if that's what you'd like to do. Do you need to speak with Mr. Mikovits before we do that, or I can put you in the breakout room?
I don't believe so, Your Honor, unless you have we've reviewed what the plea would be, and I think we could take him through that process. And Mr. Mikovits, you can let me know if we need to talk separately, but I think he understands the process.
I do understand.
Oh. All right, then. So what is the plea offer, Mr. Donaldson?
I'd call on Mr. Patterson for the recitation of that.
So, Your Honor,
Mr. Patterson.
Mr. Mikovits would be tendering a plea to operating while intoxicated, and the high BAC charge would be dismissed.
Okay, and Hang on just a moment. All right, so there is a pretrial memorandum to that effect. Mr. Mikovits, is that your understanding of the plea agreement as well?
Yes, it is, Your Honor.
Has anything else been promised to you other than dismissal of the high BAC charge to get you to plead guilty to the operate intoxicated?
No, sir.
Have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, sir.
Was that a no?
Yes, no, sir.
Oh, okay. Has Mr. Pedersen answered all your questions to your satisfaction?
Yes, he has, Your Honor.
Okay. Do you understand if you were no longer able to afford Mr. Pedersen's services, the court would appoint an attorney for you at public expense?
You understand?
Okay. Do you also understand that you will have by pleading guilty, you will have a conviction for operate while intoxicated, and that carries a maximum penalty of up to 93 days in jail?
Yes, I understand.
All right. I need to go over your trial rights with you and make sure you understand all of those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand all those rights?
Yes, I do.
In addition, you have the right to have the witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if necessary. Do you understand all those rights?
Yes, I do.
In addition, you have the right to testify at a trial, or if you choose, to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes, I do.
Finally, by pleading guilty, you give up the right to appeal that you'd have if you went to trial, and any appeal would be by leave, not by right, meaning it would be up to the appeals court whether to even hear any appeal of your conviction or sentence. Do you understand that right?
Yes, I do.
And do you understand and agree to waive all those rights in order to plead guilty?
Yes, I do.
Okay, so the complaint alleges that on February 3rd, you were driving your car on Southwest Bayshore Drive in Elmwood Township in Leelanau County, and somehow the police had contact with you. Is that true?
Yes, sir.
Okay. And is it also true before driving you had consumed some alcohol?
Yes, sir.
Would you agree that due to your consumption of alcohol, that you had at least a 0.10 blood alcohol concentration, or that you, because of consuming alcohol, you were a substantial danger to other people on the road?
Yes, sir.
Okay, then to the charge of operate while intoxicated, how do you plead?
Guilty, sir.
All right, I'll accept your plea. It's clear that it is voluntary, understanding, and accurate. And so what I'll need to do is get a pre-sentence investigation report and a substance use assessment, and we'll have you back for sentencing at a later date. Ms. Odom, can you work Mr. Pedersen on a date there?
Mm-hmm. How about July 2nd at 9:15?
I can do that, Your Honor.
Okay. So we'll be back here on July 2nd at 9:15 in the morning. Now, I'm going to need you to contact our probation office to set up the interview and the substance assessment. And here's the number you want to call. It's 231-922-6985. 6899.
I got it.
Okay, call them after 1 o'clock this afternoon, but before they close at 4:30. And again, they'll set up the appointment and the assessment, or unless you have your own assessor you want to use.
Mr.
Okay, we're
Mikovits,
all
did you-
set then?
Yeah, I think we're set. Mr. Mikovits, did you get an assessment yet? I couldn't recall.
Through Munson.
Okay, so make sure you let the probation department know you have that and bring it with you for your appointment.
Okay, will do.
All right, thank you, Mr. Pedersen.
Thank you, Your Honor.
All right, we're all set then for today. Feel free to sign off at this time.
All right, I'm off the
We'll be in
record.
recess until our civil docket beginning at 10:30. What I'd like to do is, let's see, we got a settlement conference and landlord-tenant case at 10:30. And
An SVD, but what is that?
set aside to
Oh,
call.
yeah.
So you might want to put parties in a breakout room if they want to talk
Sure.
on those. And I'll probably go to the set aside default before I do the other two then.
Okay. All right. Excuse me.
I'm supposed to get my blood drawn at noon.
Are you giving blood or just
No,
checking
I'm
your?
just a regular laboratory for a physical.
You didn't have, are you fasting right now?
Yeah, so I'm fasting, so if
Oh.
I seem a bit sluggish. It's
My God. Where are you going? Because they're the one out by the mall opens at 7. So you can like fast all night long and just go right in.
Yeah, no, I usually do get it first thing in the morning, but they didn't have an appointment at my doctor's office. They have their own lab
Oh, all right.
till noon that I could do.
Oh, all right.
So.
Oh,
that's
yeah. My
fine.
God, I would be. I'm gonna make right now. Oh, giant bagels. Sorry. Right? Sorry, what time do you have your appointment? Okay, sounds good. Morning. Okay, are the parties here for Midland Funding LLC? Anyone here from Midland Funding? And can you guys hear me?
Yes.
No, not, okay. Thank you. All right, so it doesn't look like anybody's here for Midland. Teeter Orthotics, are the parties here for Teeter Orthotics? Looks like Mr. Hubble's here.
Yes, Your Honor.
And Zayas. Okay, well, and I'm Tammy. I'm Judge Cooney's recorder.
Can't see it from that angle.
So do we have a resolution today, or it's a settlement conference, actually? Okay. Have the parties spoken?
Yes. We went
Okay,
through
and
mediation. I mean,
Yeah, we went through
Okay.
mediation and
we've communicated. We're not having much luck. We'll still
Not
work
having
on
much.
it.
Okay, but you don't want to speak today? You feel like you're kind of at a plateau, but you're going to take time to try to work things out?
Jaw always works better than war, but sometimes it doesn't, it's not possible. But counsel and I have worked together responsibly and professionally, and I'm sure we will continue, and we'll see if we can't put something together. Is that right, Joe?
Okay.
yeah, that's accurate.
Okay, so I'll relay that to the judge. Let's see, I see Ms. Glancy here on the Gateway case.
Yep, good morning.
Good morning. Who's on the other side there? Is that,
My client was just here. I don't know what happened to him, but Mr. Miller, that's representative from the plaintiff. And then the defendant is Mr. Enderby, Michael Enderby, and I don't know if he plans on attending. I know he was served, but I haven't heard anything from him recently.
okay, and Mr. Miller is your client, the plaintiff?
Yes, that's correct. He was
Okay.
here. I don't know.
I'm still.
I
here.
see him.
Okay.
Yep,
Oh, he's there.
I
Okay.
see him.
I don't know.
Okay, Mr. Enderby is unrepresented, I'm guessing?
As far as we know, yeah.
Okay, but he's not here yet. Have you had any discussions with Mr. Enderby at all?
My client briefly made contact with him over email, and he said that he knew he needed to move out. He never really even hardly moved in, other than just a few boxes and filing cabinets, and he never paid any rent. So he knew he was far behind it. I got the impression he wasn't ever going to try to pay to stay or anything. He was going to vacate, but then. Unfortunately, then he just kind of disappeared again. As far as I know, we haven't heard back from him again after that. Is that correct, Adam?
That's correct.
Okay. Yeah.
But he still has stuff in the home?
Yeah, it's a business suite, and he has, just not much, but a couple boxes and filing
Okay.
cabinets, and we just, we figured it's best to just get the judgment and go that route, because it doesn't seem like he's committed to getting out of there.
Okay, now I do see somebody that just showed up on 231-883-6822. Who are you?
Yes, my name is Jeremy Sutphin. I work for Adam Miller.
Oh, okay. Jeremy, what's your last name again?
Sutphin, S-U-T-P-H-E-N.
All right, and you're here on the Miller case, on the Gateway case.
Yes, ma'am.
All right.
I think Jeremy was actually the one that had corresponded with Mr. Enderby. So.
Okay. All right. In case you need testimony.
Yeah.
All right. So that sounds good. But we're going to have to give Mr. Enderby 15 minutes. So another 8 minutes or so to see if he shows up. Okay.
Sure.
All right. So let me get the judge and let him know what's going on here. And anyone here yet on Midland funding? Okay. Let me check this guy. Yeah. Okay. All right, so it looks, who is under Wells Light?
Wellington Lightbourne versus Midland Funding.
Yeah, okay, so I've called the Midland case a couple times, but nobody's responding. So you're the defendant in that case, correct?
Yes, ma'am.
Okay, have you had any discussions with anyone from Midland?
No, ma'am.
Because they do have an answer, so we're kind of surprised they're not here, but I'll let the judge figure this one out. We're not really sure why they're not here, so. All right.
Okay, thank you, ma'am.
You're welcome.
All right, good morning. We're going to start with Tito Orthotics and Prosthetics versus Larry Gooden. And let's see, Mr. Hubble is here for the plaintiff and Mr. Zayas for Mr. Gooden. And this is the dates for a settlement conference in case number 205073 GC2. So it's my understanding that the parties are still working together to try to come to a resolution. Is that a correct statement, Mr. Hubble?
Yes, Judge. I don't know that we've made much progress recently, but I don't think that the lines of communication have been shut off. Is that a fair statement, Joe?
Yeah, I think that's accurate.
Okay.
There hasn't been a whole lot of movement, but we're still trying.
All right. Well, let's see, the pretrial order was signed back in January, so it looks like the period for discovery has closed. Has it? Is there any? Are there any outstanding issues as far as discovery or pleadings go?
I don't think so, Your Honor.
I don't think so, Your Honor.
All right. So we have this scheduled for a 10 a.m. to 5 p.m. Trial, non-jury trial. Is that still going to work for both sides?
Yeah, I don't see it going any further than that if it gets there.
I would agree, Your Honor.
Okay. Well, I would like, if this does end up going to trial, I would like to get trial briefs and any exhibits 2 weeks prior to that. And we'll be getting a notice out of the date for the trial. I don't think that's gone out yet. Is there any objection to holding that trial by Zoom?
No, in fact, Your Honor, that would be preferred as my client has mobility issues and it would be very difficult for him to get to the court.
How about you, Mr. Hubble? You agree?
You know, Judge, I don't much like the Zoom, but I'm getting used to it. So yes, we'll be glad to cooperate. And I would agree, Mr. Zayas's client has mobility issues. I think it would be a burden for him to attend in person.
Okay, well, my feelings exactly, Mr. Hubble, but I think we need to get used to this because we got an order from SCAO the other day telling us that we do need to conduct as many of these hearings by Zoom as possible, not just during the pandemic, but in the future. So looks like it's going to be a way of life. So
a brave new world, Judge, a brave new world.
Yeah, well, we may be able to get this set sooner because of that. Ms. Odom, did you have a question?
I do. Is it a bench trial or a jury trial?
Yeah, this is a bench trial.
Thank you.
All right. Are there any other issues then we need to discuss before you go?
I'm not sure what time frame the court is looking at for a trial. My client actually, even as we speak, is undergoing heart valve replacement surgery, so maybe out of commission for at least a month, if not a couple months. So I don't know what the court's time frame was, what the schedule looks like, but it might be beneficial if we could set this out a little ways, and hopefully in the meantime, Mr. Hubble and I can get this worked out.
What about 90 days? Does that sound?
Yeah, that should be fine.
Mr. Hubble, any concerns about that?
No, Your Honor, I recognize Mr. Zayas's client has some health issues, and you know, it's ridiculous to try and force him to participate when he has legitimate health issues. So we'll be glad to cooperate in that vein with the court and Mr. Zayas.
Okay. Ms. Odom?
Yeah, 1 day or half day?
Oh, it's in the pretrial memo, we decided on a 10 a.m. to 5 p.m. trial.
Thank you.
So basically a full day, but we'll stick with that. So, all right, you will get a notice then of a hearing date, the trial date, at least 90 days out from today. And hopefully your client will be in condition to attend. So unless there's nothing else, we're all set for today, and I appreciate your appearance.
Thank you, Your Honor.
Thank you, Your Honor. Thanks, Joe.
Thank you.
All right, let's go to the Gateway case, and that's Gateway of Traverse City LLC versus Michael Enderby. And Ms. Glancy is here on behalf of the plaintiff. Is Mr. Good morning. Is Mr. Enderby present? All right. This case was set for 10:30 this morning. It is now 10:47 a.m. And Mr. Enderby has failed to appear. And there's no representative. So, Ms. Glancy, what sort of relief are you looking for?
Well, in light of Mr. Enderby not being here, Your Honor, I'm asking the court to sign a default judgment. We did provide a proposed judgment to the court. We're only asking for the possession today, as the damages were over the dollar limit for district court. So we're just asking that the court sign that default judgment and ask that he be evicted within 10 days.
Okay, I do have the order that was prepared here. Let me just take a look at it. All right, so this is a default judgment. It indicates the plaintiff has the right to recover possession of the property, and the plaintiff can apply for an order evicting the defendant if the defendant does not move out on or before, let's see, June 14th. Does that sound right?
Yes, that's correct.
There's no money judgment entered at this time. And, well, I'll go ahead and sign that order. And that'll be filed with the court. So anything else on that matter, Ms. Glancy?
No, nothing further, Your Honor. Thank you very much.
All right, thank you. All right, do we have anyone here from Midland Funding?
I got an email from Noreen. Let's see. Cindy called, and let's see. Midland is expecting to be here. Cindy is calling them, and now Noreen's asking me, did Midland show up yet?
All right. I see Mr. Lightbourne is here.
Morning, Your
Mr.
Honor.
Lightbourne. And there's also an Adam Miller. Mr. Miller, which case are you here on?
He was on the Gateway case, Judge.
The what?
The Gateway case.
Oh,
He
Gateway,
was,
okay.
yeah, he can go, he can sign up.
All right, so Mr. Lightbourne, I was surprised when I heard Midland Funding did not have a representative here, because they did respond to your motion to set aside the default. And I believe that was as late as June 2nd. So we've emailed them, and hopefully they'll be here in a couple of minutes. So we'll be in recess, and I'll be back at 11 o'clock. We've got a preliminary examination at that time, unless they get here sooner.
Period. All right. Mr. Travis, are you here? Is Melissa Cutting here? Anyone from Midland Funding here?
The only one here, ma'am.
Oh boy, sorry, Mr. Lightborn, hang on there.
Ma'am, is this acceptable that they come late?
Well, they're not here, so they're not coming at all, and I don't know why. And we've emailed them, so I'm not sure what the judge will do. We'll see what he's going to do with that. and on Travis's case.
Okay.
Ms. Cutting. I don't know what's going on with the prelim.
All right, so we're gonna get started on Midland Funding versus Wellington Lightborn. This is file number 194597 GC2. And this is hearing the defendant's motion to set aside the judgment. Actually, motion to set aside a default. And so Mr. Lightborn is here. There's no one here from Midland Funding, but we're going to go ahead with the motion anyhow. So Mr. Lightborn, do you want to go ahead and argue your case?
Yes, sir. Good morning, Your Honor. Your Honor, I
Good
said
morning.
from the get-go that this account is not mine. Only thing I ever wanted from this whole case was to see a contract. That's all I ask. They have not provided a contract. I've been fighting this for almost 4 years, and they have not provided me a contract. All they provide me is statements. That's what I find very weird.
Okay, well, this is the thing. This was not a default judgment. You were present for the hearing.
Exactly.
Default is when someone doesn't show up. So as pointed out in Midland's response to your motion, the judgment was actually a summary disposition. And that means that I heard the evidence on both sides and found that there was no meritorious defense to the plaintiff's case that you owe this money. And in fact, I reviewed your answer to the original complaint. And again, there's no meritorious defense. It merely denies all of the allegations. A denial, a general denial, is not a defense in itself. There has to be more than that. Also, as I recall, the proper documents were presented at the time of the summary disposition. That would include the agreement that was transferred to Midland Funding. So for a variety of reasons, the motion is denied. First of all, because it's not properly filed. This was not a default judgment. It was a summary disposition. But looking at the arguments that were made by Mr. Lightborn, I see no reason to set aside this court's original summary disposition judgment. So that's it. And we're all set for today. All right, Ms. Odom, are you trying to track down Mr. Travis and the defendant for our preliminary examination?
Miss Casties, are you there? She'll pop back on. You know anything about Mr. Travis or Miss Cutting?
Yes, that got adjourned.
Oh, sorry, it was on
The
our
judge signed
docket.
that adjournment slip in order to adjourn 2 weeks yesterday.
No,
Ah,
it was still
okay.
on our docket, so we didn't know. Okay,
sorry.
Okay, well, thank you.
that's okay.
All right, we're all
Thanks,
set
Noreen.
then. Thanks, Noreen.
Right, you're
Have a
welcome.
nice weekend.
Well, you too, and we're sure surprised about Midland. We have no idea.
Yeah, odd. I hope she's okay.
Yeah, that's odd because
Yeah.
they just filed their response, so.
Yes, and indicated they couldn't wait to, to have the hearing, so I
Oh,
hope
okay.
everything's okay down there.
Yeah.
Yeah.
Okay, well,
Okay.
you can let them know they won anyhow, so.
Oh, okay. We will. Thank you.
All right.
All right, take care.